So OPE review of criminal law and criminal procedures together. Looking at conspiracy. Under the common law, at least two people must agree, this is plurality of agreement, and they have intent to achieve an unlawful purpose. An undercover officer does not count towards plurality under the common law. Now, conspiracy is completed at agreement, therefore no overt act is required. You also need not know the act was illegal, meaning ignorance that the act is illegal is no defense to conspiracy. If feigned and or fake agreement, then no conspiracy. Again, you must have plurality of agreement. Under the conspiracy under the model penal code, and this minority jurisdictions, conspiracy under the model penal code is a unilateral approach. This requires agreement by the defendant, but not by two or more parties. Here, the undercover officer agreeing with the defendant under common law would not be plurality of agreement here, and you couldn't be charged with conspiracy under common law. Under the model penal code, you can. Kind of a shitty way for officers to entrap you into conspiracy. Looking at attempt, common law attempt, agreement is irrelevant. Conspiracy is agreement. Attempt, common law agreement is irrelevant, but it does require some act beyond mere preparation. Attempt, common law, requires some act beyond mere preparation. Attempt and murder requires substantial step towards completing and specific intent to commit. Attempt, if a crime is committed, attempt merges into the crime. Example is a hitman shoots a dead man. The most he can be found guilty of is attempted murder. When the term aggravated is used, this involves the use of a deadly weapon. You're going to have deadly force, self-defense. You cannot use deadly force when you're receiving accidental blows. This is insufficient to rise to self-defense and deadly force. This is the hedge trimmer that accidentally hits somebody, then they go and try to stab the person with the hedge trimmer. Looking at murder under the common law and intent, no specific intent to murder is necessarily required. It may be depraved heart murder or the intent to inflict serious bodily harm. An example of the latter is hitting a friend in the head with a hammer after the friend throws a beer at and breaks your TV. Voluntary manslaughter. For voluntary manslaughter, you must have adequate provocation. Burglary, actual, quote, breaking, end quote, is not required. Just the use of force to create an opening into a dwelling, such as pushing open a window. Looking at searches and seizures, drivers temporarily detained for routine traffic stops, they are not in custody for purposes of Miranda, and statements freely provided may be probable cause for further search. Search and seizure and Fourth Amendment violations, they only apply to government actor and or agent. An example would be a private party is encouraged by a government actor or agent or offered a reward for acting, they may be considered a government actor. Search and seizure and considering in custody, this is where you reasonably believe you are not free to leave. An example would be officers entering a bedroom of a sleeping man with guns drawn, waking him and immediately asking questions. Their Miranda is required. Looking at jeopardy. Jeopardy attaches at a bench trial when the court begins hearing evidence. Jeopardy attaches at a jury trial when the jury is sworn in. Jeopardy does not attach to preliminary hearings and or grand juries. Looking at self-incrimination and lineups. When you're required to speak at a lineup, such as the words spoken to the witness by the suspect, such as "give me all of your money," this is not testimonial, and this may be compelled. Now, the right to counsel in grand juries, you have no right to counsel inside the grand jury room. Right to counsel and out-of-court identification, even if it's improperly suggestive. Suppression of in-court testimony is not required if the witness's identification is shown in court to be reliable. Looking at intoxication, intoxication must be voluntary. Now on exam, look for facts that appear non-obvious intoxication issues. The example that I'm going with is the athlete taking performance-enhancing drugs and a battery results. Then that may be an intoxication issue. This defense applies in that situation, but must be, again, voluntary. So maybe they took, and that fact pattern was they took something thinking it was an aspirin when it turned out to be steroids, is the insinuation. Now looking at a trick question for criminal law and criminal procedures. This is where they ask you whether a conviction for robbery, where the defendant was trying to recover their own property, should stand, or burden of proving he was trying to recover his own property, his defense, is placed on the defendant. Now they cannot place that burden on the defendant. You cannot permanently deprive someone of your own property you are trying to recover. And that completes OPE review of criminal law and criminal procedures.